I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my general co-host, Brett.
Ah, yes. General me. That's what I am, Alice, leading the charge. Today, I'm planning on being sort of the general of the couch because we have, as we often do, someone far more interesting than me to talk to our listeners.
It's true, Brett. I was actually just going to cut you off and say, please stop talking, because the real reason we are here today is we have the Attorney General of Alabama, Steve Marshall, here with us, but not to talk about politics. Instead, we are here to talk about one of the most mind-boggling cold cases of our generation that was cracked by his office, and he actually led the charge and trial that led to a conviction just in the last year of J.B. Beasley and Tracie Hawlett, who were murdered back in 1999. General Marshall, thank you so much for being here with us today.
No, thank you for having me. By the way, a word of thanks to the two of you for helping us train law enforcement last year. Your listeners probably don't know that you were doing a panel for us with all of Alabama's finest and incredible reviews that you offered some commentary and help for law enforcement doing their jobs better. So thank y'all for doing that.
Thanks for trusting a couple podcasters who could really lead things astray, because I'm going to give a spoiler alert. There's so much to talk about in this case, and we want to hear from you. But one interesting element in this particular case you're here to talk about today is social media and bloggers, in the sense of talking about police corruption and how that may have affected the case when it was absolutely cold and there were no significant leads. So that's kind of a teaser for you guys out there listening, because this case has it all. And social media and its influence, negative and positive, is something we talk a lot about in the true crime space.
Right. Look, this one is unlike any case that I've ever handled. In 16 years as a local DA, 7 years as Attorney General. Although I will tell you, not trying a case for almost 6 years is not like jumping and riding a bike again. It was an interesting transition to be able to handle it. But to do it in a case like this, 24 years being tried after two precious 17-year-old girls died, was a unique challenge for me as a lawyer and as a prosecutor, but also just a remarkable opportunity to provide justice to two families who desperately needed it.
And before we get too much into the case itself, and you just touched on it a little bit, tell our listeners a little bit about you. There are a lot of different paths to Attorney General, but you may be one of the most qualified people to ever serve in the office. So how did you end up the Attorney General of Alabama?
Well, qualified, we'll take that as a compliment, but no, I've had a strange practice, honestly. Came out of law school, worked for one of Alabama's largest law firms, did securities litigation. Y'all, really exciting stuff, right? Suitability churning, that's what your listeners want to talk about. And then just sort of what led me into the practice of law was being able to try cases. And so left to go to a small town in North Alabama, beautiful place. And it was really as a result of being required to defend a case involving a gentleman by the name of James Arthur Williams, who was charged with attempted murder. I was appointed to represent him. It was my first true jury trial. And literally James Arthur had shot a guy in the back claiming it was self-defense. And when that case was over, the jury found him not guilty. James Arthur shook my hand and walked out the door, and I wondered what I had done. I mean, it was literally, I'm on the wrong side. I didn't feel great about what we'd accomplished, and clearly did not feel like that's where I wanted my talents to go. And I just told myself when I had a chance to become a prosecutor, I wanted to do it. And in 2001, had the chance to become the district attorney of a jurisdiction in Alabama of a little over 100,000 people. Did that for 16 and a half years before 2017, I had a chance to become Alabama's Attorney General. So incredibly blessed with what I've had a chance to do, but it's the ability to speak on behalf of victims in law enforcement is the reason why I think God put me in this place.
And just to give the listeners kind of an idea of the types of cases that you tried when you were DA for, 16 plus years, what types of cases did you see? Were they violent crimes, white collar cases, the gamut? And which ones did you enjoy the most?
Yeah, I tried anything from a misdemeanor harassment to capital murder. I mean, and you do that when you're a rural prosecutor. You know, you have relatively small staffs, and you jump in and do what you're supposed to do. You know, and interestingly, I'd try a murder case all day long compared to a DUI, for example. DUIs are not easy, and in fact, pretty complex technically. And so I just enjoyed the ability to be an advocate. And so it really didn't matter to me the severity or the type of crime. As my sort of in leading that office, one thing that I did do is take for many years all of the child sex abuse cases, the child pornography cases, just kind of felt like that was an area of specialty that I wanted to get. But also, when you're the district attorney in a community, they need to see you trying the violent cases, so that when we had rapes, murders, those types of things, I was definitely going to be involved. Now, uniquely, I think in 16 and a half years, we had less than 20 murders in the jurisdiction that I served. So, you know, we didn't have, you know, like we see in many cases, you know, murder after murder in a community. And so that's very fortunate. But yet, there wasn't anything that I wouldn't try and that I didn't love trying.
And just because I have you as a captive audience and we have the benefit of you being a prosecutor for over 20 years, are there any trends that you saw in your time as a prosecutor? And this is meant to be open ended, that you saw either in the types of crimes or the perceptions that the jurors had shift over time in the more than 2 decades that you
Yeah.
practiced?
Yeah, I think it's really the rise of forensic science. And it's kind of in two tracks. One, let's take forensic odontology, bite mark evidence. You know, that was something that was historically used over the years for purposes of being able to identify an individual as part of a crime. And you began to see challenges from multiple sides as to whether or not that's a true science. And in fact, how it is that that becomes admissible. And then conversely, you had DNA that came on the scene. You know, O.J. Simpson, frankly, is probably the seminal case where people talk about it, where it was challenged. Is it legit? Is it something that we ought to accept? Where the defense clearly was working very hard to discredit it, and now it's the gold standard. And so, you know, it's been interesting to handle a capital murder case where forensic odontology in a little courtroom in Marshall County, Alabama, we had experts from all over the world really debating the legitimacy of that type of evidence. Whereas in the McCraney case, for example, there was never a doubt as to whether or not that was his DNA that was found vaginally and on the clothes of J.B. Beasley. And so the defense was not, this DNA is a hocus pocus, but instead it was for them, how do we explain it and explain it in a way that doesn't link him to the crime. And so what I found is that juries had unreasonable expectations probably about what type of forensic evidence could be offered. You know, you're not going to, you know, just everything that you touch or everything that you're engaged with have DNA. And it's one of the reasons why child sex abuse cases, for example, are so difficult, is because you typically, particularly around a touching case, for example, you're not going to have any forensic evidence to offer. And they become a credibility contest to some extent. And it's why the work that investigators do is so important, to be able to support the testimony of a child, but also the work that's done by people in child advocacy centers, for example, is so critical to be able to help support the statement of a child. But what I found, and one of the things that was unique in my jurisdiction, y'all are aware that North Alabama is the land of engineers, right? I mean, those around the space industry and Huntsville, you know, we had a disproportionate amount of engineers that were potentially in our jury pool. And I'll share a little secret that the two of you may not appreciate. I had sort of three absolutes for me, if I could, when I was picking a jury. I didn't pick a teacher, a preacher, or an engineer, right? And there were unique reasons for each of those. But for our engineers, I found them the ones that demanded the most and had the highest expectations when they really didn't have an understanding of what crime scenes are like, what a forensic analysis can provide. And to some extent, you almost had to prove more to an engineer just because of their thought process than otherwise the law would require. But, you know, there's no doubt that CSI effect is real, and we began to see it and train prosecutors around it. But yet, what a prosecutor really does is just simply tell a story. And so whether it's got forensic evidence or in our case, highly circumstantial evidence combined with DNA, it's the responsibility of that prosecutor to tell the persuasive story about what happened and use the tools that you have to be able to do it with.
So I want to transition to the case, but I can't leave our listeners hanging. Why not teachers and preachers?
I found that teachers were just the ones that were sympathetic and wanted to give that second chance. And preachers somewhat the same way, is they've heard those stories. They really want the best of everybody. They want to see the best in everybody. And we just found that they were far more empathetic than they were wedded to the facts. And, look, there's not a, I know we have jury consultants and they provide thoughts and advice, but y'all been there. When you're sitting there striking that jury, many times it's just kind of gut reactions. And those were some of the things that, when you're trying to decide between people you don't know much about, and clearly it's a generalization that I'm using, but it was just a way for me to distinguish whether to keep somebody or not.
No, these generalizations we've talked about a lot, that we have to pick juries kind of on the fly within a snap, and you have to make snap decisions about someone based on very limited information. And as a result, you have to make those kind of broad brush strokes. I bet you we have a lot of teachers, preachers, and engineers listening right now who want to be on a jury who are like, oh man.
Yeah, I won't share my secret too broadly.
Well, what's interesting about the case we're going to talk about today, or one of the many things that's interesting about it, is how cold it was. I guess based on your life story, this crime occurred before you even became a prosecutor. All the way back in 1999.
That's interesting. I never actually thought about that. Yeah, and what's interesting is, although I was living in Alabama and here, I didn't even know about the case from the news. Now, I think if I'd have lived, I was, again, from North Alabama. Had I been Montgomery South, I think I would have clearly been aware, because this case uniquely had a life story that came with it, because there would be news, be anniversaries of the girls' deaths. They put it back out there. You had multiple agencies, both state and federal, come in at some point in time to be able to solve it. And one of the things I think is unique about this, this is truly, Ozark is rural, small town Alabama. And for the people of that community, there remained this sense of, we don't know who did this. And are they still here? And are our children and our families at risk? Now, it was clearly a heightened sense of that right when it happened. But I don't know that it ever completely dissipated, because there was always this sense of, who could have done this to two obviously very innocent, precious young girls, and to commit the crime in the way that it was done.
And with that, can you take us back to 1999 and walk us through the facts of that fateful night and what the public knew at the time?
Yeah, so two 17-year-old girls, J.B. and Tracie, good friends. J.B.'s guardian was out of town, and so she was going to stay with her friend Tracie. Tracie was working at the local J.C. Penney. We don't say that very often anymore, right? That just shows you how old this case is. At the Dothan Mall. And what they planned to do, because it was J.B.'s birthday, is to go out. There were some friends of her that were having a party in an area just north of Dothan, which is, for those that don't know, kind of in the Wiregrass area of the state of Alabama, and the kind of the southeastern portion of the state. They were going to go up and visit their friends, go to the party, and then come home. And Tracie's mom told her very specifically she had a curfew, had to be back by 11:30, and the girls were going to wake up and go to church the next day, and JB was going to stay with them. And so once Tracie got off work, they came home, got in the car, and they left. As the girls were traveling to that party, they got lost, and they ended up at a location called the Big Little Store in Ozark. By the way, your listeners are going to hear something that they probably don't hear very often, and that's a payphone, because a payphone came in play, because when they got there, they had no idea where they were. And so as they're at the store at roughly, I think it was 11:30 that night, they called Tracie's mom to say, hey, we gotten lost and we're going to come home. And they were actually trying to stay out a little bit longer, because you would imagine 17-year-old girls want to be able to see their friends because they didn't get to go. And uniquely, there were a mother and a daughter that had come to that same store at the same time and had been worked all day kind of renovating a house, and they wanted to get something to drink. And as they drove up, they saw the girls, and Tracie and JB came over and said, can you give us directions? And then that's when they went and made the phone call to Tracie's mom, and she told them that they could go home and and see the friends briefly and tell them hello, and then expect her to be home not long after curfew. And sadly, it was shortly after the mother and daughter left the Big Little. That's the last time that the girls were seen. And the next thing that anybody knew was the next day when that Mazda 929 was parked on kind of a rural road inside the city, but kind of in of Ozark, but in a street that was not very well developed. Eventually, those two girls were found in the trunk of a car, both shot and killed.
And I mean, whenever we hear these stories, 17 years old, they had their whole lives ahead of them. And like you said, this is a very rural, tight knit community, and something like this just doesn't happen. I know you said when you were a prosecutor in North Alabama, you had, 20 maybe murders in that time. I would say similar for this area. Is that right? I mean, it's a farming community. It's like the peanut capital of the world. There's a lot of farmland, and it would not be unusual to be able to be out late and expect your daughters to come home safely. Just to give our listeners kind of an idea of this community, were murders typical in this area? The road that they were on, I'm envisioning kind of these backwood roads with not a lot of lighting, paved, but really just two lanes, one for one way and then one lane for the opposite way. Is that kind of the road that they were found on?
Yeah, the road they were found on actually was a residential street. It was just one where there was not any houses that were developed. And so it was a little out of the way, dark road, not a lot of traffic would go in and out of that area, and one that was honestly a good place to drop a car and get away where nobody could be able to see you. But there's no doubt, I mean, look, this isn't Mayberry doesn't exist, right, other than with Andy, but it was definitely a safe community, a tight-knit, close community, and one, while not immune from crime, did not see crimes of this nature, and especially involving what occurred here, which was two girls in the trunk of a car who were clearly shot while they were in the trunk of a car, and then their bodies taken to a different location, as we have hypothesized, and left there to be found later.
I mean, so with that, they were found the next day, but then take us through kind of the early days of the investigation. What did police know and what did they not know? And what happened in terms of the resources and the jurisdictions that came in to help with this investigation?
Yeah, so the way it really got started was Tracie's mom was tired that night. She'd had a long day at work. So she went to bed after telling the girls to, be home pretty quickly. And she woke up that morning and neither Tracie or J.B. were at the house. She immediately calls the local police department. The girls lived in Dothan, which is about, 30 minutes or so from Ozark, maybe not quite that far. Tracie's father had been a police officer in Dothan and unfortunately passed away when she was young, raised by a remarkable man by the name of Mike Roberts. So Tracie's mom knew law enforcement in that area, and she called and said, "Hey, Tracie's not home. What can we do to help?" And so they put out a bolo for the girl's car. They began calling friends that they were supposed to see that night, and the friends said, "Hey, they didn't ever show up. We didn't see them." And at some point, one of the Dothan police officers is sent to begin looking for them. They become aware of a 929 that is found on the side of the road. Bolo was for that car. And it was police secured kind of generally that area, but didn't do anything to look inside. If I recall, one of the windows was partially down. The car was sitting there, and eventually that Dothan police officer arrives, sees what he believes is some suspicious looks inside. There was kind of a mud print that was on the floorboard of the driver's side. And one of the things that was, I think, an important piece of evidence for us, and I can't recall whether he noticed it to begin with, but the rearview mirror was laying in the floorboard, which is obviously to me a sign that there was violence that took place inside the car. And so that officer looked and eventually popped the trunk, and it was when he popped the trunk is when the girls were first discovered. And that obviously is when multiple law enforcement agencies got started. You had kind of a collection. At that time, Alabama, through our state troopers, had a division known as ABI, or the Alabama Bureau of Investigation. One of the real heroes in this case is an investigator by the name of Barry Tucker. And Barry has lived this case his entire life. And one of the more gratifying things when the case was over is to look at Barry and say, we got the guy, and knew that he was held accountable. Because you can imagine And I've heard some of the stories of law enforcement afterwards. Law enforcement is generally pretty hardened, sadly, because we see these things. But when you see a child, and particularly when you see two 17-year-olds killed, it's tough. And so this is a case that lived with people for an awful long time. So you had ABI that was there. You had the Ozark Police Department, because it happened in their, or at least the car was found in their jurisdiction. You had Dothan Police Department a little bit involved just because of the fact that the girls were from there, as well as the local sheriff's department was a part of it. And literally, it was a all hands on deck. We had two 17-year-old girls killed for absolutely seemingly no reason whatsoever, almost killed execution style, because they were shot in the head, and you could tell just where their hands were and how they were found, that they could see themselves about to be shot because they were trying to guard their face from it. And there were absolutely no particular leads to begin with. And so kind of everything was in play. Lots of people were calling in with stories that just simply didn't check out. And I do think one of the more unique aspects of this case is that over the first several weeks, not really much that they had to go on that was helpful. And then ultimately, after a reward is offered, they have somebody show up at the police department and wants to tell a story. And that person was arrested after saying that he had been with the person that did it, didn't know him, and picked him up. But yet it was really based on his story alone was that initial arrest. And as they began to check into what he had said, the reality is it was clear that he wasn't even telling the truth, that he thought, I think he thought he was going to get some quick money, right, with that reward.
The problem with
he'll
rewards.
say it. Yeah, and then suddenly he didn't realize, hey, I've just kind of implicated myself. And but yet, despite being charged initially, I think obviously they did the right thing to dismiss that when they realized that was all a fabricated lie. And as you would imagine, and Alice, Brett and I at least share that Alabama lineage. In small town Alabama, rumors can flourish, right? And when this case isn't solved, everybody and every hypothesis is offered out there, including in this case, that law enforcement was potentially involved in her death. There was a witness that testified at trial, but that had come forward at some point and said that he had seen a car matching the description of the one the girls were found in near a law enforcement vehicle. And at one point in time, maybe a law enforcement vehicle was behind a black Mazda 929. And this was where a little of that law enforcement conspiracy argument came from, or at least the rumors themselves. But yet over the years, there were all kind of leads that came and were checked out and never came to fruition. And the one thing, that they knew fairly quickly based on the autopsy is that for J.B., that vaginally and on her bra and on her sweater, it was positive for semen. And so they were able to do DNA. And y'all, this is one thing, we talked earlier about it. The science and the technology around the DNA analysis really expanded over the years. And so, there was only certain parts of the DNA that could be attested initially back in 99. We began to be able to test more of that human genome and be able to derive more analysis over the years, which they continue to update it. But at least then we knew that we had the bad guy. We just didn't know who it was. This was uplifted to CODIS, no hits. Anytime that there was a lead, they would check it out and they would ask for consent to get DNA. And in fact, I don't know how many law enforcement officers ultimately gave DNA, but it was a bunch. They were more than happy to vindicate themselves.
Oh, you're saying that law enforcement officers were doing that because of the conspiracy that law enforcement was somehow involved?
Right.
Oh, wow.
Yeah, they had people saying that, X, Y, and Z were involved in this. And so as investigators should do, they ran it down and those people were able to consent to give it. So there's, one thing that I think y'all can imagine, this jumping ahead a little bit, is I had 4 months to get ready for a capital case. That was the time we had it was at that point almost 24 years old. There were boxes and boxes and boxes of records relating to this investigation. 90% of those had to do with random calls or leads that came in that law enforcement had to run to the ground. Because as you can imagine, eventually when you're trying this case, part of the defense is going to be, did you look at Fred? Fred was supposedly at the Big Little on that night, right? And to the extent you hadn't done your due diligence, regardless of how fanciful the claim was about who else was involved, they had to do their job. And so, every time somebody came up as a possible suspect, law enforcement did a good job of being able to run it down. And the reality is that this sort of case really did go cold, not because of lack of effort or interest, but just simply there wasn't anything else to look at for law enforcement to deal with. Because again, what we knew is the last place the girls were seen was at the Big Little, that we knew they were supposed to go home based upon what the mother and the daughter overheard of the cell phone call. And at that point in time, the trail, it just vanished. And so DNA was always going to be the linchpin of what was going to take place. But yet, despite the fact that our forensic science lab would continue to update the analysis, continue to make sure that it was part of CODIS, there never was an opportunity for there to be that match.
And then genetic genealogy comes along, and there's an opportunity to do something that very few jurisdictions had done, particularly at that time. Were you guys able to take advantage of that?
Yeah, and a lot of credit goes to Chief Marlis Walker, who was the chief at the time there. And, he had grown up in that community, knew that this was something he wanted to solve. And then, the wonderful case in San Francisco, right? I mean, it's the first time, I don't know about y'all, that was the first I had ever heard of genealogy DNA being, and let's describe it correctly, an investigative tool. It is not an admissible piece of evidence necessarily, clearly not in Alabama. And as somebody who'd spent a little time digging in the law before we tried this case, it is still something the courts are trying to grapple with and how it is even admissible at all, but definitely an investigative lead. And so what Chief Walker found as a result of what he learned from the case in California was, let's give it a shot. What do we have to lose? Memo to your listeners, be careful about being a part of 23andMe and whatever other private genealogy, because your DNA is out there for sale when you give it up. And so they sent the sample from what they acquired off of JB's body, and they were able to get back a report that lists multiple surnames that could be potential leads. And as the chief was looking at that report, he noticed one name, and it was familiar to him. The last name was McCraney. And he immediately thought about his high school classmate, who ended up being Coley McCraney, and said, I need to find him, because the lab told him is, if you can get somebody within this kind of tree of names we've given you, we can narrow the scope. We can eliminate people basically so that it becomes a little more focused.
So the chief actually went to school with Coley McCraney. They were in high school together?
Went to school with Coley McCraney. I think they played basketball together, if I'm not mistaken. And it's why sometimes you got to be lucky. And you make your own luck, right? In that the chief was at least diligent enough to use the tool that genealogy DNA gave him. But the call to Coley McCraney, because McCraney was seen on the sheet, was just pure coincidence, because the desire of law enforcement at that point in time was to get Coley to provide us DNA, allow us to narrow the focus, and then maybe they could take those leads and move out. Because by this time, we'd had FBI come in with a team. You had the AG's office at that time, had a cold case unit. So you had all these people that continued to work the case and just were running it to a dead end. They were going to reactivate the team and try to run down some of these additional leads. And so...
And this was 2018, 2019?
Yeah, I think that's about right. Mm-hmm.
And you're saying that on that list, it could have been like, he could have called any of those people. They just needed kind of a willing participant to give one. And the fact that the first one he called was one that he recognized from high school, Coley. And the reason we're focusing on this is going to be very important, who he ends up calling.
Yeah, and Coley was not a suspect. At this time, Coley was a long-haul truck driver. As I understand it, at least from trial, was leading a congregation potentially in the area which he lived.
In fact, a preacher, maybe one of your three not to be on the jury.
Yeah, exactly.
There you
go. Claimed, and I'll sort of be transparent here as well. We didn't find any real criminal history during his adult life. Coley would have been around 24 at the time the girls were murdered in 1999. And so he was not somebody, for example, whose DNA would have been in the CODIS database. And so Chief is able to make contact with Coley. He's coming in from some long trip that he had taken. He was married to a woman by the name of Jeanette, who he was dating in 1999, but only subsequently married after that. And Coley and his wife come to the station. I think the chief had talked to him briefly on the phone and kind of told him a little bit about what they were trying to do.
Did he mention that it was this case?
I don't recall whether he mentioned it as this case. I think he may have just said, we're working on something and we're trying to develop a family tree, and here's kind of how we can help. But Coley comes to the police department with his wife. And this was, I think, really kind of an interesting sort of moment. The one that the defense characterized in a very different way than we did, because there was no legal process to compel him to provide DNA, not a suspect at all. Had that been the case, we could have got a search warrant to be able to do it. So Coley comes in there and he meets alone with the chief at this point. Coley explains to him, hey, do you remember the murders of the two girls in Ozark in 1999? I think Coley kind of said, yeah, I maybe remember that. And he said, did you ever met those girls? You know anything about them? And he denies knowing anything about either of them. And he says, well, hey, we'd like for you to give us your DNA, and that'll help us try to solve this case. Are you willing to do it? And Coley didn't say yes initially. He said, can I go talk to my wife? And so he comes and gets his wife and brings her in there. And he asked the chief to explain again what he wanted to do. And after the chief says, hey, we want his DNA, what was interesting is his wife said, Coley, you don't have anything to hide. And if they want my DNA, they're going to have my DNA too. So he is at a point of decision, right? He can either go no, because of concerns he might get caught, or, and by the way, would have to explain to his wife why I said no. Like, what are you hiding? Or he could just say, I think I had sex with one of those girls, Jeanette, and just wanted you to be aware of it. But he ends up, after his wife made that comment, said, yeah, I'll do it. And that's when he consented to the DNA.
And real quick, because this is just going to, this just blows my mind that he willingly gave his DNA after he'd been explained to that this was the specific case they were looking into, whether he knew their names at the time or not. I mean, a double murder, shot execution style in the back of a trunk, that case doesn't come around a lot. It certainly didn't in the past 24 years in his neck of the woods. So he knows what's about to happen. Do you have any theories as to why he even wants to talk to his wife? Why not just say, I don't know, I think that's a bunch of baloney. I don't like anyone. I don't like Big Brother knowing, my DNA. Why did he even bring his wife in there to ask her?
I think, a couple of things. One, I think at that point in time, he's thinking, I am in the throes of a dilemma, because I do believe that they'd had a conversation before he got there where she kind of knew what they were asking him to help with. And to the extent that he refused to do it, he's got some splaining to do, as they say in the South. But also, I do think there's probably a little bit for him in the decision to give, is they hadn't caught me in 20 years. Why do I think it's going to catch me now? Nobody saw me. Nobody's identified me. Nobody's connected me to it. And maybe he felt, a little bit foolproof in that regard. But yeah, that's honestly, it's one of the, everybody, and y'all have been here too, there's a point where you always want to talk to a defendant and go, why'd you do that? Right? Explain what you were thinking. And we don't get that privilege as a prosecutor to be able to have that question. But, the defense at trial wanted to make kind of a big deal of the fact, well, he voluntarily gave his DNA. I firmly believe that he did it because he was unwilling to explain to his wife why he wouldn't have done it.
I think that makes a lot of sense. And I often say that if the police ask someone if they can search their car and they say no, that person probably doesn't have anything in their car. Whenever it just blows my mind the number of times that police officers will ask somebody with no reason, they've got no reason to do it at all, but ask somebody if they can search their car, and they're like, "Sure," and they have a kilo of meth.
Yeah, and by the way, that's where the engineers always come in and go, "Well, there's no way he would do that if he knew it was in there, right?"
Yeah, that's a
why
good
would
point.
anybody do it? But it's Alex, it's a great point. And so from that though, they send that Coley's DNA to the lab, and they get a report back within 2 weeks that says he's your guy.
What did the investigators do?
Oh, I mean, it was all hands on deck. So they was not long after that, reached back out to Coley and say, "Hey, we need to talk to you again." He's driving his rig into Ozark, and they take him down with a traffic stop, and that's when they arrested him. Now, a couple things that they did post the DNA. Turns out that they were able to locate that roughly within, and I'm use rough distances, but within a mile or so of where Coley was living in 1999 was the Big Little, and within roughly a mile of where the car was found is how far his house was from that location. So they didn't arrest him solely based on DNA, but what they did arrest him on was proximity of where he lived and the DNA connection. And you two have been around enough in actual cases and what you've studied through this podcast. It's not a lot, and yet everybody was certain that he was the guy. And what's interesting is it's one of the only cases I've ever been involved with that got better over time and not worse.
Were they ever able to locate the firearm that was used?
No, still not to this day. They were able to identify generally what it was as a result of the tool marks examination that was done, but no, never found the gun. And also, we were never able to tell the jury where it happened. And that was, again, when you're looking at what are your obstacles in proving your case, that was one of them. But what
I remember,
yeah, go ahead.
I was going to say, I remember from the facts that the blood had sort of dripped down on the undercarriage of the car, and you could tell that the car had moved after that happened by the blood patterns. And so they knew the dump location wasn't the site of the murder. It had to have occurred somewhere else.
Yeah. The other thing, both girls were found with muddy jeans. And the one thing that the mother and the daughter were able to testify to at the Big Little was the fact that both girls were dressed fine. There was nothing about their clothing that was unusual. Definitely no mud or stains on their jeans. And then that's how they're found in the case. And again, one of the things that is also, I think, fascinating about this case is we were able to use some of the most technical evidence you can find, and that being the DNA, and leverage that with the most basic element, and that was mud. Because I think, to me, one of the most persuasive parts of this case was the fact, and the reason why persuasive, because McCraney ends up testifying that it was consensual sex, and oh yeah, I met this girl, and we can talk about that in a second. But with the forensic examination that was done, not only did JB have mud on her outside of her jeans, but also mud on the inside, which I argued, and I think correctly so, that was evidence of the rape, not consensual sex. Now, also McCraney said they had sex in the back of a 18-wheeler's cab, but the jury didn't buy that at all.
Explain to us what you mean by that. This is very fascinating. The mud on the inside of the jeans, how that helps you tell the story that this is not consensual sex, but a rape.
Yeah, partly you got to use a little bit of common sense. We got a 17-year-old girl. What 17-year-old girl is going to have sex with a boy in the mud somewhere randomly at night?
With her girlfriend there.
Yeah, with her buddy. That's just not going to happen. And it was mud that was found on her skin and inside, which demonstrated, I think, correctly and persuasively, that she was forced to take off her jeans, or at least pull down her jeans, that she is forced to have sex in the mud, and then ultimately pulls her pants up before she's put in the trunk of a car. And It's just something, there's no way to explain it otherwise. At 11:30 at night, she and her buddy are perfectly dressed. When they're found murdered, both of them are muddy, which also shows to me that Tracie was put in that same location, probably with gunpoint to keep her quiet, and that's when her friend was raped in her presence. But it's also, again, evidence that we could argue as to why this wasn't a consensual sexual act, but instead was one of force.
And I want to talk about his testimony because I think it's some of the most damning testimony that a defendant's ever given. And, just very quickly, since we're on this, to highlight this, and you mentioned it briefly, even if he could have argued, oh no, we went off in the bayou and it was muddy, but whatever, that she liked to have sex in the mud. That's not the story he tells. Like, the story he tells doesn't account for the mud at all. It's like you said, it's in the bed in the back of his truck, his big rig truck, and just completely undermines that. I mean, even if you're out there thinking, oh, well, people have sex in the mud all the time. Yeah, he undermines that himself. But before we even get into that, so we've talked about the investigation. We've talked about how we got the arrest. How did you get involved?
Weird story. The jurisdiction that handled the case, basically in Alabama, 90+% of the prosecutions are handled by local district attorneys. We have 42 in the state. They do a great job. A lot of my friends are there. This case was handled by the DA in the jurisdiction where Ozark is, who was in place in 1999. He had eventually retired, but cared so much about this case that he wanted to be able to try it. And he was eligible to do that through a program in Alabama called supernumerary. And name is David Emery. And David stayed with this case throughout. And interestingly, they came to try it the first time and were not successful in being able to begin it because they couldn't get enough jurors to be able to strike a jury. Various reasons why, nothing nefarious, but they just couldn't strike the jury. And David is known to be quite the cyclist and really good endurance athlete. And he was in a bike race and got in a horrific bike wreck. And the judge was pretty determined to try the case for the date that was set. And I got a call from the local DA there in November of 22. He said, hey, we need some help. David's been in a wreck. And I remember he said, I need your A team. And I said, well, am I good enough? And he's like, what? I was like, yeah, I mean, is it okay if I come personally and handle this? Because I knew about it because as the AG, they invited me to the press conference when McCraney was arrested. That's when I first knew a little bit about it, but that was about it. And so he was like, absolutely. And so I and another prosecutor in my office by the name of Jimmy Thomas, who's just a gifted and talented prosecutor, were assisted with Emmett Massey, a local prosecutor there in Ozark, and we became the trial team. And it was, 4 months of an awful lot of work. But what was, just bizarre about it is we should have never been the ones trying that case. But for David's injury, and David's doing better now, which is good. But one thing, y'all, I think is also kind of fascinating is David had sort of sketched out how it is that he was going to try the case. And at that point in time, there was still the lingering witness. There was a person that wanted to say law enforcement was absolutely involved and they were the ones that did it. And it turned out that she ended up coming to a hearing saying, yeah, I just lied about it. It was all hearsay anyway.
And she wasn't a witness to the case. She was just like a vlogger or
a random person in the community who loved to post. And so they actually had a hearing. But what's maybe even more interesting about that hearing, and this was right before the trial that was aborted. I told you earlier that this is one of the few cases I've ever seen gets better because remember what we knew was we had his DNA vaginally and by the way, it was semen. That was the other thing we made clear. It wasn't just DNA, it was semen. So vaginally and on the clothes. We had the location of where he was living in proximity to the Big Little and to where the car was found. We knew that he moved shortly after the murders to another location away from where he was. But y'all, that's really, again, the evidence that tied him together. And in that hearing where they were testing the evidentiary value of Renee Crumb's testimony, she's the one that ultimately admits to lying. Coley McCraney's wife is called, Jeanette, to the stand. And it's at that point that folks on the prosecution and law enforcement side hear for the first time that on the night of the murder that Coley McCraney's car was at the Big Little. I mean, it was absolutely amazing that it was through the course of that testimony. And again, y'all know this, there's a marital privilege. You couldn't ask that question to her to be able to find out after he was arrested, although uniquely they were not married at the time. So potentially she could have had to testify to it before. But that was like a seminal moment. It's like, holy cow, we have him at the scene where the girls were last seen by the two women, which didn't see another car, didn't see the vehicle. But Jim McCraney testified that his car was broken down there that night when he came home. And she testified some to a timeline and what have you. But that was huge. I mean, that was absolutely huge for us, to the point, I think it's also maybe the first time I've ever called a defendant's wife to testify in the course of the trial. And she was one of our witnesses that were able to make that connection. It was interesting. Also, you see what some local media write about your trial when it's going on. And somebody wrote that was really when she testified at trial is when kind of the light bulb started going off for everybody about the connection that he had beyond just the DNA.
We talk about this all the time, how dangerous it is to have someone close to the defendant testify, whether it's a loved one or whatnot, because they may have an incentive to lie to protect their loved one. Obviously, when he came into the police station back in 2019 or whatnot to do the DNA sample, it seemed like, based on her comments, she thought he had no involvement. But then, of course, ultimately, he's tied by his semen to the crime scene and then is indicted and is now in trial. By the time she's testifying for the prosecution, was she still on his side? Was she a willing or hostile witness for you all?
She was declared an adverse witness early because she was not there. Now, I don't mean to say that she was not cooperative in showing up and all those things. She did exactly what the law would require her to do. But no, she was not there.
But she had not denounced her husband or...
Not at all. No. And in fact, still supports him to this day from everything that I have seen. But she had testimony that we thought was essential. And so we obviously called her in our case in chief. But I think that was obviously significant for us in being able to establish his presence there on the night of the murder.
So tell us a little bit about what you got from her testimony. And, for the listeners who don't know what an adverse witness is, it's essentially that the person doesn't want to tell you. You usually can't lead a witness, but if they're declared a hostile or adverse witness, then you can lead them, especially because you had prior sworn testimony to be able to impeach her. But it's not always a great look for the person taking the testimony, because you never, especially as the prosecutor, want to look like you're dragging testimony out of someone in any way. We've always talked about how it's always a show for the jury. The jury is always judging whether they like you as a prosecutor, and having to be a hard charging prosecutor, especially to a seemingly completely innocent woman, can be very, very delicate. So, I'd love to hear how you handled that adverse part of it, and then what you were able to get out in facts. And as you said, it was kind of the bell that went off in a lot of people's heads after she testified.
Yeah, we knew that she was going to paint a timeline that was somewhat helpful for us, although not completely consistent with what we think the facts were. Because not only did she put his car there on that night, late that night, she describes him coming home walking. And then what she said, they went back to get his vehicle at the Big Little sometime earlier that morning. She was not, as some witnesses are, incredibly combative. It was just very obvious that she was not there as our witness. And I think that was pretty clear. But I think the key for us was making sure that not only did we get out the information we needed to get out, was also to demonstrate that she was fully aware that of the crime that was committed, the fact that it was well known in the community that the last place the girls were seen was the Big Little. And neither she nor Coley McCraney ever came forward to be able to say, oh, by the way, we were there that night, if you want to talk to us about what we saw or what we didn't see. And they were never one that came forward with any information. Yeah, the interesting thing, too, about the defense strategy is, you're kind of damned if you do, damned if you don't. I mean, most times I think lawyers, defense lawyers as well, will say the defendant really doesn't gain anything by testifying. But, what do you do here? You have semen on a girl that, and when he was arrested, he was asked, do you know the girls? No. Are you familiar with anything about them? No. Have you ever met them before? No. So he was already locked in with this idea, I don't know who you're talking about. And yet your DNA is on these girls and you can't explain it. So do you allow him to get up there and be subject to cross-examination? Or do you let the jury have to figure out how in the world could his DNA be there and he is given us no explanation, or the defense has given us no explanation as to why? For example, if there's a witness that would have known they had sex, they would have brought them to be able to say it, and maybe he doesn't have to get up there. But when there's nobody else to offer anything based on the story he was telling, it's a tough call. And so I've been asked, well, gosh, did they make a mistake? Well, Monday morning quarterbacking is always there, but it's almost like they had to call him because otherwise they had no explanation or how your DNA shows up on somebody that you say you didn't know. No.
I think they absolutely had to call him. I just think his story, he should have done a better job crafting his story to the facts.
Well, one of the things is funny, J.B., who was the one that was raped, was always known as J.B. How she called it? He called her Jennifer. He said he met her at the Dothan Mall and that they had exchanged information and that she had called him a couple of times. And by the way, he was living with Jeanette, but he told her to call him at his mama's house. And it's like, okay, that's strange. Again, by the way, we're not in the world of cell phones. He had a beeper. That's what he talked about. And then tried to tell the story that the reason he was home was because JB had called him and she was going to come see a guy that she'd only met briefly at a mall on her birthday and bring her friend. And so they were going to meet at the Big Little, and then they don't show up. And he goes to see his son that stays with his mother. And then suddenly his car breaks down. And lo and behold, the girls are there. And he's just there to assist them to be able to get home. And he says that he wants to show them a shortcut to get to their house, knowing that the girls were late getting home, which he acknowledged. And so he drives them down this road, and that's where he happened to have his truck. And so he's got to show them the truck, and that JB gets out and Tracie gets out. And of course, JB then crawls in the cab and then goes immediately back to where the bed is. And Tracie goes back to the car with a guy she'd never seen before at all. And that's where they have sex. And then they have to drive him all the way back to where they came from, past the Big Little, away from Dothan, to take him home. And then they go home. I mean, again, absolutely a bogus story. And, one of the things that, I don't know about y'all, but I like to watch the jury's facial expressions and how they're responding when somebody's testifying. And you could just tell that they're like, this really isn't making sense. But the challenge for me as a prosecutor was usually you've got a statement to be able to review, or you've got something you can use to impeach. Y'all, I'm hearing the story for the first time, writing on my little tab on my table, hearing the story the same time the jury is hearing it. And so what I'm having to process is, with so much, frankly, that I could do, how do I target this cross-examination to truly show that he's lying? And so that, I think, was professionally the unique struggle for me, was what is the best approach to that cross-examination? Because that, look, every prosecutor worth their salt dreams of that moment, honestly, because it's like the ultimate test in a courtroom, which is, can you use your skills to show that somebody is truly lying? And you got to do it without documents. You former federal prosecutors that you are, y'all love your exhibits and documents. But how do I do it just by the strength of my questions to demonstrate the fallacy of his story? And it's 2 hours of my life I'll never forget. And I just remember sitting down when that was over, thinking we're in good shape.
So you mentioned this, and we talk about this sometimes too, and we got a lot of young law students and lawyers out there, and I think some people think cross-examination should go on for a long time and you should hit on everything, but I think you're 100% right. You have to focus on something. What was your focus in those 2 hours?
It was really this idea of, we're talking about two 17-year-olds. What 17-year-old that's already got a plan to go to the party of her friends is going to go on her birthday and see a total stranger? It's just like, doesn't make any sense. And if it was for some romantic rendezvous, what other 17-year-old is going to stay in the car while they're friends with a total stranger all alone? That was one thing. It's just like, that doesn't make any sense. And then they're already late going home. You have two witnesses who have no reason to lie, the mother and the daughter, who've said, yeah, they were kind of in trouble because they were late. They had to get home and they had a very limited time to do it. So were those girls going to get in a car with a guy they didn't really know, travel toward their home, because he said he was going to show them a shortcut, but travel toward their home, get out, explore an 18-wheeler, stay there for 15 or minutes or so, according to his testimony, then drive all the way back where they came from to take him home, to turn around and then go home? I mean, again, makes no sense. And clearly, two girls who are already in trouble because they got lost and they're out late, mama having told them to come home, and suddenly they take more time to be with him. It just didn't make common sense. And in some ways, you can have all the technical evidence you want, but you really ask the jury never to forget the fact they ought to use their common sense. They don't have to accept everything that's heard as somehow another gospel. And this is one that I think they just absolutely fundamentally couldn't believe.
I mean, I love that because, the break in the case after 20 years was some of the most complex, cutting edge technology that we're continuing to see develop, genetic genealogy, forensic genetic genealogy specifically. But what you're describing here, what basically breaks him down, is pure common sense and connection with the jury and storytelling. And we say that so often. We say this about our listeners and people who are observers of the justice system. The justice system is supposed to be open to all. It's supposed to be accessible to all. And we're all supposed to understand it because this is our system, right? These are the rules that we as a society have decided to abide by and hold others accountable to. And it's really refreshing to hear that it's not this new fandangled science or, the smartest of the smartest doctors having to come and explain to all us, lay people who know nothing about how to solve these cases. No, it got you the break that, we needed after 20 years. But at the end of the day, it truly was human level connection of how people think, how people act, and Occam's razor. We talk about that a lot. What is the most likely story? A girl on her birthday who asks permission to stay out a little bit past curfew so she can see her friends on her birthday, to then instead kind of take this detour that is not fun for her friend Tracie, I would imagine, makes no sense whatsoever. And people don't have to understand how the human genome is mapped to understand that core basic human story that you're telling. So I think that was just, beautifully told, that no matter your technology, you have to explain it to the actual facts before you, because you have, at the end of the day, 12 jurors sitting there who have lived experiences, who can hear and use their own reasonable minds to decide whether McCraney is lying or not. So,
and I think, the biggest challenge to us in telling the story was after, you're talking about that discrete period in 1999. You can talk about how they were shot and killed, what they collected, the fact that they found DNA. But then you got a gap of 20 years. And so Alabama has never had a case in which genealogy DNA evidence has been considered. And how is it that you can offer any limited testimony relating to that? Because, there's, unlike the final analysis that was done where they can give you the population studies that show, you're one in whatever, number is out there of being somebody else's DNA. Here, it was just that lead that got us to Coley. And we were concerned because the genealogy DNA report is not admissible. How could we even explain that we got to Coley to begin with? Because if you're sitting on that jury, you're going to wonder, well, gosh, what was the break that got them there? It wasn't some witness that came forward and told us. And so we were very strategic. And this is a capital murder case too. So The fact that death penalty is on the table means you got to be even more careful about how you try to make sure there's no error on the record. Is we were going to be very, very conservative in how it is that we're going to deal with it. And it was just really going to be not being able to talk about it at all. And we just knew that was going to be a struggle. And one thing that the defense lawyers wanted, part of their strategy, was there to be some understanding, because they wanted to talk about the fact that he voluntarily gave his DNA. And so they're the ones that really put that out before the jury. And in some ways it helped us, because then we could say, yeah, that's the reason why, is because we did this initial report and we were able to narrow him down and we got there. But absent their willingness to do it, that would have been that gap that I think would have been something the jury would have thought about, is like, why this guy now? Because, we definitely could not offer that as direct evidence in our case in chief.
That's really interesting. And you had the added kind of human element that he had never been in trouble with the law. So, 20 plus years had passed and he never got in trouble again. I mean, two double murders is pretty serious, but you've got to think this preacher who had been married to the same woman for 20 plus years, had never committed a crime, in his adult life, now is sitting for a double homicide. There's kind of no crime more serious than that. And if you weren't able to explain that gap in time to tie him to him as a suspect 20 years later, I can imagine a lot of the jurors thinking, surely you have the wrong guy. If you have the right guy, you would have done this 20 years ago, and or he would have done something in the interim.
Mm-hmm. No, absolutely. Trials, you can plan them all you want, but they never play out exactly like you think they're going to. And this was one of those nuances that we didn't expect, but we're, in this case, pleased to be able to help fill at least maybe a problem for us. But it was also, again, part of the strategy for them. And I get it too. It's like, well, gosh, why would he volunteer if he hadn't done anything wrong? I mean, he wants to be cooperative. He wants to be able to help. And that's the narrative they tried to tell.
So one thing we've sort of learned from genetic genealogy is it is more common than we thought that people will kill once and then stop. Used to be, we thought if you did something like this, you would do something again. But I am curious, he is a long haul trucker. Have any other jurisdictions with unsolved homicides of a similar nature reached out to you about him?
Not me personally. And so I don't know whether law enforcement has heard, but his genealogy now is in that national database. And so to the extent that ever showed up, they could look at it. But to my knowledge, nobody else has ever contacted us.
So kind of jumping to the end of trial, the jury is, the case is submitted to the jury. How long did they deliberate? And, what did they come back with? And were you nervous during that interim?
Oh, you're always nervous. I mean, and y'all tell me if you disagree. The worst feeling in the world is when you finish the rebuttal close and you sit down. First of all, you're exhausted. I mean, you're absolutely exhausted from what's going on. But at that point, you lose all control. You can't argue anymore. You can't offer any more evidence. And it's literally the most helpless feeling in the world. And so jury got the case roughly after lunch on, I want to say a Tuesday. I may be wrong about that. They deliberated that afternoon, went home, came back the next day, deliberated a full day, and then they rendered their verdict the following morning. So basically, pretty much 2 full days for the jury. And the case took roughly 10 days to try, I think, if I'm not mistaken. So one of the things that I found, at least in my tenure, is if you're going to make a jury sit for a couple of weeks, beginning with jury selection, to go through everything it takes to even get the trial going, they're going to take their time a little bit with the evidence. It's like, okay, now it's our turn. We've had to listen to these lawyers argue. We've had to be able to go into these breaks and they don't tell us what's going on and then they call us back. This is one that it was their time, and have every firm belief that, for 2 days they had some thorough discussions and, looked at a lot of things that were going on in the course of that trial and reached the conclusion that I think was absolutely spot on. And that is that Coley McCraney killed both of these girls and then he raped J.B.
And you mentioned it was a death penalty case, but I know in the end, the jury recommended life without parole. Were you surprised by that at all?
No, it was 10-2 was the result. And in the penalty phase, the defense offered numerous witnesses that talked about kind of his life and what he had done and his impact on their families. And there were very compelling testimony from individuals. But look, it was never about the decision on what to do, whether it was life without or death. it was about holding him accountable and convicting him. And, you know, it was, and, you know, if you've never been in the position to argue a death penalty case, you can't completely understand exactly what that argument is like. But this one was different than any I had done before, which was, look, here's what we understand from the facts. And it was a single aggravator that we offered. And so it was interesting. There was an additional aggravator that could have been in play, but it didn't get adopted until 3 months after the girls were killed. So we had to go back to the law in 1999 to deal with it. But I just told them that the family's going to accept whatever decision you make, that we leave it to the jury to decide which they weigh. And that's the way Alabama's statute worked, is you weigh aggravators and weigh mitigators, and that's where your choice comes. And 10 of those jurors believed it should be life without. And we accepted that and moved on, and now continue to work to defend that conviction.
Has he maintained his innocence to this day?
As far as I know, yeah.
Okay.
So we continue to see that in the filings and public comments from family members and others. And look, you know, you talked about it earlier. I mean, this case was all over social media. I mean, and, you know, everybody and their brother. And, you know, I'll back up and say, you know, there's somebody that again has tried a bunch of cases, and they're noteworthy cases in the community in which I was in. I've never had a case where the number of people showed up that were in that courtroom to watch this trial. Because I think there were people for a long time that said, how is this the guy? You know, we don't, you know, they don't know the underlying facts and everything, but it's like, this is somebody that's from this community. We think we know a little bit about him, and how is it him? And so there was a lot of curiosity from all different segments of that community that wanted to hear firsthand what had happened. And so it was one of the few times that I've ever been in a courtroom where it was really just packed. And I mean, I think it sort of takes us back to maybe, you know, trials of many, many years ago, where it was really the kind of the community that came together to see what was going on. And that in and of itself made this case, I think, pretty unique as well. But social media had all kind of theories as to, you know, whether he did it or not, and people parsing through, you know, records that they weren't even privy to. I have absolutely no doubt he's the right guy, and that he committed these offenses.
And that's a really good point here. You know, he obviously testified, but I don't think we really know what happened that night, except that based on the facts, it appears to have been a random act of violence. The girls were in the wrong place at the wrong time. The mother and daughter who saw them happened to leave probably a few minutes too early.
Yeah.
If they were there and there were witnesses, perhaps he wouldn't have done that. And it appears that his car really did break down, if his wife's testimony is accurate.
So I'm not accepting that completely. Or, you know, what she said is they had to go back and go jump off his car, and, you know, he could have easily disguised that in some way.
I mean, with that, as we're closing out, though, I'd love to hear if you, because the enduring question, you know, we think you have the right guy. Finally, there's justice for J.B. and Tracie, and there's some closure for the Wiregrass area. But the why still seems so senseless. There are still so many young women, parents, who are still scared because this still happened to J.B. and Tracie. Having lived through the trial and lived through these facts, do you have any theories as to what happened that night? You know, if they were the targets of his violence, or if they just happened to be in the wrong place at the wrong time?
Yeah, you know, it's interesting. One of the stories about this case is entitled Wrong Place, Wrong Time. And I really think that's the case. No reason for us to believe that prior to the evening where this took place that they had ever encountered one another. I firmly believe that his car was parked at the Big Little, that he gets in the vehicle with the girls and directs them where to go, takes them to a muddy field. He rapes JB, and to keep from being identified, he kills both girls in the trunk of the car. He drives the car to that location where it's ultimately found. He walks back to his house and he tells Jeanette, my car's up at the Big Little, let's go get it. I think that's exactly what happened.
And going back to what Brett said earlier, and maybe anyone who's listening, that just seems like such a bold, audacious crime that it would shock me that this is the first time you ever commit something like that, whether it's sexual assault or murder, kidnapping. You know, there's a host of things that he's doing in there that are so dangerous for a first-time criminal. The fact that there's two two women as opposed to girls, as opposed to just one. It's much harder to control two people, even if you have a firearm. And so I'm so glad that you all never gave up on this case after decades and kept up with the advances in technology to bring justice to the girls and to Alabama. But I also do wonder if there will be additional breaks in other jurisdictions' cases in the time to come because he is now uploaded to CODIS thanks to your conviction.
Yeah, and I think that's the unanswered question. And one of the postscripts to this case is, look, I'll never forget when the jury came back and found him guilty, looking at both the mothers. That's the kind of the heart moment. But it was also, there was so much rumor about the local police department and whether they were involved, that this was about vindicating them as well and pushing back hard against the fact that many of them were subject to scandalous rumors that were completely untrue. And we actually held a press conference afterwards, and it was important for me to emphasize that not only did we hold the offender accountable, we refuted those rumors that were unfounded and untrue, and particularly that were unjustified against the law enforcement community.
Amen to that, because we know that type of, conspiracy of law enforcement involvement didn't start in 1999. It
Right.
continues to this day, and it's rampant, and it has real effects on law enforcement being able to be trusted by the communities that they're trying to help. Witnesses, unsurprisingly, may be unwilling to talk to who they believe are law enforcement who are corrupt. So I think that's a really strong message here, and it is one that I think will be well received by a lot of our law enforcement listeners who often write to us that it is incredibly, incredibly damaging to have people out in the social media spouting off about conspiracy theories involving law enforcement founded on absolutely no evidence. And we call to task law enforcement who mess up all the time if there is evidence of it. But in this case, and in many cases we've seen, it can do a lot of harm and impede justice rather than, somehow lead to truth.
Yeah, and people want to have faith in their law enforcement community, and this was one that was damaged at the fault of nobody. They did their jobs.
And based on a lie, based on a self-admitted lie at this point. There was no foundation to it whatsoever, and yet it had spread across social media so quickly and could have undermined this whole case, but fortunately wasn't allowed to do so in the end.
Yeah, and by the way, I should say we had an outstanding judge. He didn't deal with the nonsense that was offered out there. He held me accountable in a courtroom. As y'all know, you get a little bit emotional, and I thought he did an outstanding job of providing the defendant and the state a fair opportunity to present their case. And, I was blessed and fortunate to have a great team that worked with us. Both Emmett and Jimmy, I told you about earlier, we had remarkable paralegal that worked with us and was there from beginning to end, and it was a collective team that, with all the work that law enforcement had done, it really took those forces to finally to land the plane and to get the conviction. And it's a unique privilege to be a part of something like that, and this is a case I clearly will never forget.
Well, congratulations to everyone involved, including you, for all the hard work on it. I would be remiss, as I mentioned earlier, we got a lot of law students, a lot of young lawyers who listen to this show. Two of them, JT and Savannah, are not only recent law graduates, but they're about to get married as well. And they are about to begin their careers as prosecutors in South Carolina. And they asked us if we had any advice for two new young prosecutors. But I think advice from you would be far more valuable than anything Alice and I could say. So what advice do you have to young prosecutors, old prosecutors, and everything in between?
It's going to sound a little trite, but pursue justice. And the thing that I think gets lost, I think people see prosecutors as people that put notches on their belt. And the folks that are the very best at it are not that type at all. They understand that a prosecutor can do as much to vindicate somebody who's wrongfully accused as they can convicting the person that's committed the crime. And my evaluation of a good prosecutor is not by their record in a courtroom. It's really about whether or not they understand their Brady obligations, the fact that there is appropriate protections for a defendant and that those need to be memorialized in every trial and every proceeding that you handle, but that your entire goal is to seek the truth and allow the truth to dictate the result in the case. And when you have that as your mission, it's really easy to sleep at night, knowing that that's the responsibility that you have, not to reach a particular result, but to instead seek the truth. And it's why I think being a prosecutor is the greatest position that you can have as a lawyer. I mean, it's the greatest privilege I've ever been given. We don't have enough people that right now really want to do that. And we need more that are driven by that pursuit. And so excited to hear that you got listeners out there that are willing to do it. You know, for me, I told you it was my sort of epiphany moment. You know, Mark Twain talked about that, you know, the two most important days of your life, the day you were born and the day you figured out why. That was my professional why. And it was the turning point for me in the career that I've ultimately been privileged to have.
Thank you so much for those wise words. And in this case that you've talked to us about today, we got to see that the prosecutors arrested someone based on their, a false story. But when they realized they had the wrong guy, they did the thing that we always say prosecutors have to do, be the gatekeeper. They dismissed the cases and probably avoided a wrongfully convicted man in that situation. And instead, investigators kept looking for the real perpetrator. And because of that, not only is an innocent man not in prison for these murders, but also we were able to find the ultimate perpetrator. But I am very hopeful that the answer to that question will lead to a massive spike in prosecutors across the nation. So thank you for instilling a lot of just wisdom into that answer and for giving us nearly an hour and a half of your time. I'm so sorry. We had committed to doing under an hour. Yeah. I just wanted to keep hearing you talk about this case and also your role as a prosecutor. Thank you for everything you do for the state of Alabama. And in this case, for J.B. and Tracie, it affects all of us deeply. Those of us who are parents, who were once 17-year-old girls at one time, who would like to believe that justice is vindicated at the end of the day. And this one, despite 24 years passing, it really was achieved. So thank you so much. And I will not keep you any longer, but do you have any last words you'd like to share before we sign off?
Yeah, I've never been on an award-winning podcast before. I mean, this is like
we paid him to say that. I hope you know that.
No, the penultimate of my career is to be in the same. No, I think it's really neat that y'all are able to share kind of the cases that are going on around the country in a way that people understand kind of what it's like. Because unless you live this world, you believe, the fictional stories that are on broadcast TV. And it never works out that way, right? I mean, it's never that easy. This is hard stuff. And the work that goes into it with law enforcement, who are always second guessed for not doing this or doing too much of that. Prosecutors who are accused of various things as a way of trying to deflect from the truth. Getting these cases to completion is hard work. And I mean, look, I got this gray hair for a reason. I mean, these kind of take years off your life. And, the two of you know a little bit more about me personally. And, my wife saw a very different side of me. It was somebody that was singularly focused on this matter and did that for months on end. And she's like, I'm glad you're back, right? Because you just get into that mode. But this is hard stuff. But I can also say it's absolutely worth it because of what you're able to do.
Well, thank you. There's no way we can top that. General Marshall, I really hope you come back again soon because I think this is going to be one of our favorite episodes for our listeners. We really appreciate the time you took to walk us through this case, to show us how difficult it is to bring a case to completion, and for sharing your wisdom as a prosecutor. We wish you all the best. And I don't know, Brett, I think we should just retire because this is going to be the best episode of all time. Well,
but thank you. This has been a treat.
Thank you. Well, you guys, you don't need a real sign off because you've heard from the best already. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. really do like playing with everyone about West Texas 3, though. It's really fun.
Yeah. And like snapping turtles. I mean, you can do a whole episode on snapping turtles. Like, was there a wrestling match that night or not? Who knows, right? It's a complete mystery.
All of this. All I'm saying is you guys are really making the case for us to do it, not...
People are just so ridiculous about this
Why
case.
are people so angry about this case? My goodness.
I don't know.
I think there are so few things in this life that are not like directly related to